My parents filed the lawsuit 19 days after we buried my grandfather. The ground above his casket hadn't even settled yet. I remember the exact moment I found out. It was a Tuesday morning in early February, the kind of cold that doesn't just chill you, it presses against the windows like it wants inside. I was at my desk at the federal prosecutor's office in Boston, coffee going cold beside my keyboard, working through a stack of case files that needed review before the afternoon briefing. My phone buzzed. A text from Derek, my closest colleague down the hall. "Call me when you have a second, it's not work." I knew from the way he wrote it. Derek Ashford has been working alongside me for 6 years. He doesn't hedge. When he hedges, something is wrong. I called him from the hallway, away from the open office floor. "They filed, Selena." I didn't say anything. "Your parents, Damon and Camilla, they filed a petition this morning. Suffolk County probate. Undue influence." And he paused. "Selena, they're claiming you manipulated your grandfather into cutting your mother out of his estate." I stood in that hallway for a long moment. The fluorescent lights hummed above me. Someone walked past with a cup of coffee and nodded. I nodded back. "Okay," I said. "Okay, that's all you've got? I need to make a call." I went back to my desk. I read the case filing summary Derek forwarded to my email. I read it twice, slowly. The way my grandfather taught me to read any legal document, looking not just at what it says, but at what it's trying to do. Then I folded my hands on the desk, looked out the window at the gray February sky over Boston, and picked up my phone. I called Margaret Tolliver. "My name is Selena Foster. I'm 34 years old, I'm a federal prosecutor, and the two people who gave me life just accused me of being a predator. If you're listening from somewhere far away, drop your city in the comments so I can see how far this has traveled. And please, stay with me until the end." But to understand why I wasn't afraid, why I walked into that courthouse months later with my hands flat and steady on the defense table, you need to understand who Stanley Wallace was. And you need to understand what he left inside a small wooden box in the bottom drawer of his desk. Because that box is really where this story begins. Stanley Wallace did not come from money. He grew up in a small house in the kind of neighborhood where the lawns were patchy and the cars stayed parked in driveways for weeks at a time because gas was expensive and there weren't many places worth going. His father was a carpenter, a good one, the kind who took pride in joints that held and edges that were level, but a carpenter nonetheless. His mother worked part-time at the school district's administrative office. They weren't poor in the desperate sense, but they were the kind of family where every dollar had a destination before it arrived. Stanley was the first person in his family to go to college. He worked his way through on a combination of academic scholarship, weekend shifts at a hardware store, and a stubbornness about waste that he carried with him for the rest of his life. He never threw away a legal pad until every line was filled. He ate lunch at his desk most days. He drove the same car for 11 years. He got into law school on a full scholarship, graduated third in his class, spent 8 years as a civil litigator before being appointed to the bench at 42. Not the youngest judge in Massachusetts history, not anyone's dramatic headline, just a man who had done the work long enough and well enough that the appointment felt inevitable to everyone who knew him. He served as a civil court judge for 30 years. He retired at 72. What people on the outside saw was a distinguished career. What I saw, growing up in his house, watching him at his desk every evening after dinner, was something quieter and more complicated. He was a man who had built his entire life on the belief that systems work when people are honest inside them. That justice isn't a feeling, it's a record. It's documentation. It's the paper trail that survives after the emotion burns away. He kept records of everything. I didn't understand until much later why that habit would save me. The money, $2.8 million in total assets at the time of his death, was not luck and it was not inheritance. It was 40 years of a man who never spent more than he earned. The house in Brookline, Massachusetts, where I grew up. He bought it in the early years of his judgeship, took out a modest mortgage, and paid it off in 18 years by making extra principal payments every month without fail. The investment portfolio was nothing exotic. Index funds, started in the 80s, automatically reinvested, never touched. A small rental property on the outskirts of the city, bought when prices were low, rented steadily for over 2 decades. An irrevocable living trust established before he retired, structured with the help of his private accountant, Victor Ashby, who had managed his finances for 22 years. That trust would become the center of everything. But I'm getting ahead of myself. My grandmother, Irene Wallace, was the kind of woman who expressed love through action so consistently that you didn't realize until she was gone how much of your daily sense of safety had come from her. She was not a dramatic woman. She didn't make speeches. She didn't sit you down for long talks about feelings. What she did was show up every single morning, every single evening, in the small and relentless ways that add up over years to something that holds a person together. When I was 6 and had a nightmare, she was already in the doorway by the time I'd opened my eyes, because she'd heard me shift in my sleep through the wall. She had warm milk in a blue mug. She sat on the edge of my bed and didn't say much, just stayed until I fell back asleep. When I was 12 and didn't make the school play, she didn't tell me it didn't matter or that there would be other chances. She sat across from me at the kitchen table and said, "Tell me what it felt like." And she listened for 20 minutes without once trying to fix it. When I was 17 and she died, suddenly, in the garden she loved, on an afternoon in late September when the air still smelled like the end of summer, I stood at the edge of the flower beds where they found her and understood for the first time what it means to lose the person who has been the ground beneath your feet. Camilla and Damon came to the funeral. They were there for 4 hours. My mother cried, and I don't doubt that the grief was real. Irene was her mother after all. But they left before the reception ended. They didn't call in the week after. They didn't call in the month after. My grandfather and I made dinner together the following Sunday, as we always did. He made his pot roast, I made biscuits that came out slightly wrong, as they always did. We ate at the kitchen table with the empty chair that had always been hers, and neither of us said much, and that was enough. I should explain how I came to be living in that house at all. I was 4 months old when my parents brought me to Brookline and left me with my grandparents for what was described at the time as a temporary arrangement. Damon had just lost a job, a position in real estate brokerage that he'd held for less than 2 years. Camilla was, in her words, in a difficult transition. They needed a few weeks to get back on their feet. A few weeks became a few months. A few months became a year, and then the conversation about when they would come to bring me home simply stopped happening. They lived in Providence, Rhode Island, less than 2 hours away by car, close enough to visit easily, far enough to make the choice to stay away feel, to an outside observer, almost geographic, as though the distance explained the absence, rather than the absence being its own decision. I don't say this with bitterness anymore. I spent a long time working through the part of me that wanted my mother to be different than she was, that kept waiting for my father to call for no reason other than that he wanted to hear my voice. I'm not sure I ever entirely stopped waiting, but I stopped organizing my life around the wait. What I know is this. In the years that followed, the pattern became clear and consistent. They came at Christmas. Most years, not all. They sent birthday cards through the mail, occasionally a week late. My mother attended my college graduation and left before the reception. My father did not attend my law school graduation because he had, as his text message explained, a scheduling conflict. My grandfather sat in the front row of every ceremony I ever participated in, from the 3rd grade spring concert to the day I was sworn in as a federal prosecutor at 29. In that same period, the years of their absence, my grandfather sent money to Damon and Camilla, regularly, quietly. The first time was when I was about 6, when Damon's brokerage business collapsed. My grandfather sent a check, then another a year later when there was credit card debt, then another when Camilla called saying they were behind on the mortgage. The calls came every year or two, always from Camilla, always beginning with, "Things have been really hard lately," and my grandfather always sent what was asked. He never told me about the money. He never said a word against my parents, not once. He was not that kind of man. When I asked, as a child, why my mom and dad didn't visit more often, he would say something like, "People have complicated lives, sweetheart. It doesn't mean they don't love you." I believed him because I wanted to, and because he said it the way he said everything, quietly, without judgment, as though it were simply a fact he'd observed and accepted. What I didn't know, what I wouldn't know until after his death, was that while he was protecting me from the truth of their absence, he was also building a record of it. Every check, every transfer, every phone call, requesting more. He wrote it all down in his careful, even handwriting in a folder organized by year, and he kept it locked in the bottom drawer of his desk. He was a judge for 30 years. He knew what evidence was. He knew what the future might require. Stanley Wallace retired from the bench when he was 72. For the 12 years that followed, he lived in the Brookline house. Now mine to visit rather than live in, since I'd moved out for college and then law school and then my own apartment in the city. But I came back every week. Sunday dinners were sacred. We played chess on Saturday afternoons when I could make it. He came to every significant moment in my life, and I tried to return the favor. He taught me to read contracts before I was 10. He had me explain the logic of arguments at the dinner table like I was presenting to a court. He took me to the library every week when I was a child and let me pick whatever I wanted, and when I picked the same book 3 times in a row, he didn't say anything except, "What do you keep finding in it?" He was sharp until the end. I want to be clear about that. The characterization that my parents' lawsuit would later try to construct of a frail, confused old man who could be influenced, manipulated, steered, bore no resemblance to the man I sat across from at that kitchen table every Sunday until 2 weeks before he died. At 84, he still read 2 newspapers a day. He still argued about case law with an exactness that made younger lawyers uncomfortable. His doctor, Dr. Patricia Okafor, who had been his primary physician for 9 years, would later testify that his cognitive function remained fully intact, that there was no diagnosis, no documentation, no clinical basis whatsoever for the claim that he was vulnerable to manipulation. He died in his sleep on a Thursday night in mid-January, quietly, in the house he had lived in for over 40 years. The hospice nurse who had been coming 3 times a week said he had seemed at peace in his final days, that he had been putting things in order. He had been putting things in order for much longer than anyone knew. 19 days after the funeral, the lawsuit landed. Petitioners, Damon Foster and Camilla Foster. Respondent, Selena Foster. Filed in, Suffolk County Probate and Family Court. Claim, undue influence. The petition alleged that Selena Foster had exploited a position of closeness and trust with Stanley Wallace during the final years of his life to improperly influence his estate planning decisions, causing him to effectively disinherit his daughter, Camilla Foster, who was, by the petitioner's argument, his rightful primary heir. Relief requested, full invalidation of the estate distribution currently in place. Redistribution of all assets according to Massachusetts intestate succession law, under which Camilla, as sole surviving child, would inherit everything. Everything. The house in Brookline, the investment accounts, the rental property, $2. $8 million in assets that my grandfather had spent 4 decades building, one careful decision at a time. Their attorney was Richard Holt of Holt and Briggs, a firm that specialized in contested estates. Holt had a reputation in Boston legal circles for being effective in exactly this kind of case. Emotionally sympathetic clients, elderly deceased, a story that could be made to sound like exploitation if you framed it the right way and kept the jury, or in probate court, the judge, focused on feeling rather than fact. I read the petition 3 times sitting at my kitchen table, a cup of tea going cold in front of me. I read it the way I read every document that crosses my desk at work. Not to react, but to understand. To see the architecture of what's being constructed and where the load-bearing walls are. The load-bearing wall of their case was simple. Selena was close to him. She was the one who visited. She was the one who called. She was, they argued, in a position to shape his thinking, his decisions, his perception of his own family. And she had used that position for financial gain. The irony was almost elegant. The very thing that made me his family, the presence, the consistency, the 34 years of actually being there, was being reframed as the mechanism of my crime. I finished my tea. I called Margaret Tolliver. 3 days after receiving the petition, I drove to Brookline. I told myself it was practical. There were financial documents I needed for Margaret, records of the house, and accounts that we'd need for our response. And that was true. But honestly, I also needed to be in that house. I needed to sit in the rooms where I had grown up and let the fact of what was happening settle into something I could bear. It was a Saturday afternoon in early February. The sky was the particular shade of white that means more snow is coming. The house was cold. I hadn't been back since the funeral, and the heat had been turned down low. I walked through the kitchen, touched the edge of the table where we had eaten 10,000 meals. I stood in the doorway of the living room for a moment, looking at the bookshelves lining the walls. Then I went to his study. His study was the room most like him. Dark wood paneling, floor-to-ceiling bookshelves, a wide desk with a leather surface worn soft from decades of use. It smelled like paper and old wood and, faintly, the particular brand of coffee he'd made every morning for as long as I could remember. I sat in his chair, something I'd never done while he was alive, some unspoken rule about that being his space. And I let myself feel the weight of it. I pulled out the bottom left drawer to look for the folder of property documents I remembered him keeping there. The drawer held a hanging file organizer, neatly tabbed. Near the back, behind the property files, was something I hadn't seen before. A wooden box, the size of a shoebox but shorter, the kind used for keeping personal documents. Simple, dark-stained wood, no lock. On the lid, a strip of tape, and in my grandfather's handwriting, in black ink, Selena, when it's time. I sat very still for a moment. Then I opened it. The first thing I noticed was the organization. The box contained 22 years of financial records. Each year was clipped separately, labeled in his handwriting with the year at the top. Within each year's packet, copies of bank transfers, wire confirmations, sometimes personal check stubs. And beside each transaction, a note, short, a line or two, in the same careful hand. C called Tuesday, said they were behind on the mortgage again, sent $22,000. Third time this has happened. D says the new business venture needs capital, sent $35,000. Did not tell Irene, she would be upset. C called credit cards, sent $18,500. She did not ask how I was. D's company has folded. This is the fourth business in 12 years, sent $28,000. He didn't say thank you. Page after page, year after year, the transfers ranged from $8,000 to $45,000, averaging 3 or 4 per year. I sat on the floor of his study with my back against the desk and read every single one. When I reached the final page, the most recent transfer from the summer before he died, I added up the total in the margin of my notepad. $940,000 over 22 years. He had sent them nearly $1 million. He had documented every cent. He had written a note beside each transaction, not with bitterness, not with commentary, but with the factual precision of a man who understood that documentation was a form of protection. He had known for a very long time what they were capable of, and he had been building the record. I was sitting on the floor of his study in the cold, with the box in my lap and 22 years of evidence spread across the hardwood when I started to cry. Not because I was scared, not because I was angry, but because I understood in that moment how much he had been carrying, how much he had seen and not said, how many years he had quietly kept the file and kept the peace, and kept me from knowing the cost of either. He had been protecting me my whole life. He was still doing it. I almost missed the envelope. It was at the bottom of the box, beneath all the financial folders, flat against the wood. Thick white paper, the old-fashioned kind sealed with red wax, the same wax seal he had used on formal court documents in the years before everything went digital. On the front, in black ink, open only when they move against you. He had known they would do exactly this. He had prepared for it before he was gone, sealed the instructions in wax, and waited for me to find them. I pressed my thumb against the seal for a long moment. Then I broke it. Inside was not a letter. It was a legal document. Specifically, a certified copy of a revocable living trust agreement bearing the name Stanley R. Wallace as grantor, signed and notarized 3 years before his death in the spring. I read it carefully, though by that point my hands were shaking slightly. Then I read it again. The trust named me, Selena Foster, as the sole beneficiary. All assets had been transferred into the trust at the time of signing: the Brookline house, the investment accounts, the rental property. The trust had been properly executed and funded. There had been no error, no ambiguity, no gap. Here was what that meant, legally. A revocable living trust is not a will. It does not go through probate court. When a person transfers their assets into a trust during their lifetime and properly funds it, those assets pass directly to the named beneficiary upon death, outside of the probate process entirely. Richard Holt's entire lawsuit was built on challenging my grandfather's estate through probate court. But the assets weren't in the estate. They were in the trust. They had been in the trust for 3 years. Holt was challenging a door that had already been sealed shut from the inside before he ever raised his hand to knock. My grandfather had not just protected me. He had made their attack structurally impossible, quietly, years in advance, without a word to anyone except Victor Ashby and the notary who witnessed his signature. I sat on the floor of his study until the room went dark around me. I didn't turn on the lights. I just sat there with the document in my lap and the box beside me and listened to the house settle in the cold. Outside, snow had started to fall. For the first time since Derek called me with the news, I felt something shift inside my chest. Some tight and frightened thing beginning very slowly to loosen. They thought they were coming for what he left me. They didn't know he'd already built a wall around it, and he'd built it with the same thing he built everything else: patience, precision, and 22 years of receipts. That night, I drove back to my apartment in the city. I didn't call anyone. I sat at my kitchen table with a notepad and wrote out everything I knew: the trust, the financial records, the notes in his handwriting. I wrote it the way I'd been trained to write a prosecution: facts first, chronology second, implications third. By the time I went to bed, just past midnight, I had 4 pages of notes and the beginning of a plan. I wasn't the victim here. I was the prosecutor, and my grandfather had already done most of the work. Margaret Tolliver's office was on the 4th floor of a brick building on Newbury Street, the kind of address that said serious without saying showy. No marble lobby, no dramatic reception desk, just a quiet waiting room with good lighting, a wall of legal text behind glass, and a receptionist named Susan who offered coffee without being asked. I arrived at 9 on a Monday morning, 2 days after I had found the wooden box. I carried a canvas tote bag that held the box itself, all 22 years of financial records, the certified trust document still in its wax-sealed envelope, and my 4 pages of handwritten notes. I had slept 6 hours, which for me, in the middle of a difficult situation, is actually reasonable. Margaret came out to meet me herself rather than having Susan bring me back. She was 58, with short silver hair and the kind of posture that comes from decades of standing in courtrooms, straight without being stiff, present without being aggressive. She shook my hand and looked at me the way people do when they're actually assessing rather than performing assessment. "You look calmer than most people I see in your situation," she said. "I've been building cases for 6 years," I said. "I know what panic looks like, and I know it doesn't help." She almost smiled. "Come in." We sat across from each other at her conference table, not the large formal table for multi-party meetings, but a smaller one by the window, the kind used for actual working sessions. I laid out the contents of the bag in front of her, financial records organized by year, the trust agreement, my notes. She read without commentary for 40 minutes. I drank my coffee and watched the street below. When she finished, she set down the final page, placed her hands flat on the table, and looked at me. "Your grandfather was a careful man." "Yes. He established this trust 3 years before his death. The assets were fully transferred and properly funded at the time of signing." She tapped the certified copy. "This isn't a will. It was never subject to probate. Whatever Holt is planning to challenge through the probate court has no legal purchase on these assets." That's what I understood. Which means the central legal question of their case, the undue influence claim, is built on a foundation that doesn't exist. They're trying to contest a distribution that didn't happen through the mechanism they think it happened through. She paused. "Has Holt requested discovery yet?" "The filing was 3 days ago. I expect the discovery request within the week." She nodded slowly. "He'll realize the trust issue quickly, probably within the first week of discovery. When he does, he'll pivot." She looked at me. "He'll stop trying to fight the legal structure and start trying to fight the story. He'll make this about who you are, who your grandfather was in his final years, whether the relationship itself was manipulative. That's where these cases go when the document fight is lost." "I know." "So we need to be ready on both fronts. The legal structure is solid, but solid isn't enough if he poisons the narrative." She picked up a pen. "Tell me everything about the last 5 years, not the legal version, the real one." I told her. All of it. The Sunday dinners, the chess games, the phone calls, the fact that my grandfather had driven to my apartment 2 months before he died just to sit with me for an afternoon and eat takeout Chinese food because I'd had a hard week and he knew without being asked. I told her about the 7 visits Damon and Camilla had made in 5 years. I told her about the birthday cards that came late, the graduation my father missed, the way Camilla had left the funeral before the reception ended. Margaret wrote steadily the entire time. When I finished, she put her pen down and said, "This is winnable. Not just defensible, winnable. But I want to be honest with you about what it will require." "Tell me." "It will require letting them put you on trial publicly. Holt will make sure the story gets out before the hearing. You'll walk into your office and people will have read things. You'll be looked at differently. People who respect you will wonder privately whether there's something to it." She looked at me directly. "Some people can't tolerate that. It breaks them down before they ever get to the courtroom. I need to know whether you can hold." I thought about my grandfather sitting in his study, 30 years on the bench, building the record in silence, not reacting, not defending himself in the wrong arena, just documenting, preparing, trusting the process. "I can hold," I said. She nodded once, as if that settled something. "Then let's build this." And she outlined what she called an 8-week preparation plan. We needed 5 categories of evidence: the legal documents themselves, the financial records with their implications, the medical documentation proving my grandfather's cognitive capacity, the historical visitation record establishing Damon and Camilla's pattern of absence, and character witnesses who could speak to the nature of my relationship with my grandfather, people outside our family who had observed it over years. By the time I left her office 3 hours later, I had a working list of 23 specific tasks. That night, I transferred them to a legal pad, organized them by priority and timeline, and started making calls. The first call I made the next morning was to Dr. Patricia Okafor. Dr. Okafor had been my grandfather's primary physician for 9 years. I had met her twice. Once when I'd driven him to an appointment, and once at a neighborhood gathering where she and her husband lived 3 blocks from the Brookline house. She was precise, warm in a professional way, and she had a particular quality I've learned to value in witnesses. She said exactly what she knew and nothing she didn't. I reached her assistant and left my name. She called back within 2 hours. "Selena," she said, "I heard about the filing. I've been expecting your call. I need to ask you something directly, Dr. Okafor." "Go ahead. Is there anything in my grandfather's medical history, anything at all, that could support a claim of cognitive vulnerability or diminished capacity in his final years?" A pause that lasted exactly long enough for me to know she was answering honestly rather than quickly. "No," she said. Stanley Wallace was one of the most cognitively intact patients I've seen at his age. His blood pressure was managed, his reflexes were appropriate for his years, and his mental acuity. His ability to reason, to retain complex information, to challenge me when he disagreed with a recommendation was remarkable. There is no diagnosis in his file, no documented episode, nothing that would credibly support what they're claiming. Would you be willing to testify to that? I'll have my attorney reach out to yours by end of week. I thanked her and wrote her name at the top of my witness list. The second call was harder. I called Eleanor Gibbs, my grandfather's neighbor of 20 years, on a Wednesday afternoon. Eleanor was 78, sharp-tongued in the way of women who stopped caring about managing impressions somewhere around 60. And she had been my grandfather's most reliable source of neighborhood news, emergency grocery runs, and honest opinion for as long as I could remember. "They filed, didn't they?" she said, before I'd finished explaining why I was calling. "Yes." "I know. Word travels." She made a sound that was somewhere between a scoff and a sigh. "I saw that woman, your mother, at the house exactly once in the last 4 years. Once. She stayed about an hour and a half and spent most of it on her phone in the garden. I know because I was weeding my front bed the whole time, and I watched the whole performance." A pause. "I'll tell that to whoever needs to hear it." I wrote her name on the list. The hardest call was to Professor Harold Simmons, who had been my thesis advisor at law school and who had written one of the 2 recommendation letters that helped me get my position at the prosecutor's office. He was 71, semi-retired, and the kind of person whose endorsement carried genuine weight precisely because he gave it rarely. I explained the situation. There was a long silence. "Selena," he said finally, "I have watched your career for 10 years. I know what kind of lawyer you are and what kind of person you are. Those are not separate things." Another pause. "Send me whatever form I need to fill out." I thanked him and hung up before I could say anything else. On a Thursday afternoon in the 3rd week of February, my phone rang from a number I didn't recognize, a Boston area code, but not one in my contacts. I answered with my usual caution. "Miss Foster, this is Victor Ashby. I was your grandfather's accountant for 22 years. I set down the file I'd been reading. "Mr. Ashby?" I said carefully. "Yes, I know who you are." "I expect you do." His voice was measured, a little dry, the voice of a man accustomed to delivering financial information with precision and without drama. "I've been following the news of the petition. I want you to know that your grandfather spoke to me about this possibility. He asked me, some time ago, before his health declined, to contact you if it ever came to this." "What did he ask you to tell me?" "He said, 'If they go to court, Victor, tell Selena about the letters.'" I was quiet for a moment. "What letters?" "I think we should meet in person," he said. "I have documents you'll want to see." Victor Ashby's office was in Cambridge, on the 3rd floor of a narrow building near Harvard Square. He was 67, with thick framed glasses and the neat, unhurried manner of a person who had spent a lifetime working with numbers and had come to trust them more than most things. He shook my hand, offered me water, and placed a manila folder on the desk between us without preamble. "Every time your grandfather sent money to Damon and Camilla Foster," he said, "a letter went with it. I drafted those letters, at your grandfather's instruction, beginning 22 years ago." I looked at the folder but didn't open it yet. "What kind of letter?" "An acknowledgement letter, 1 page, plain language." He folded his hands. The letter documented the amount being transferred and classified it explicitly as a conditional loan, not a gift. The condition was stated clearly. If the recipient ever initiated legal proceedings to contest Stanley Wallace's estate or estate planning decisions after his death, the full outstanding balance of all transfers received would immediately become a recoverable debt enforceable through civil litigation. The room was very quiet. And they signed them, I said. It wasn't really a question. Every one. 22 years, every transfer. Damon Foster's signature on 31 letters. Camilla Foster's signature on 31 letters. I opened the folder. The letters were organized chronologically, oldest on top. The formatting was clean, the language precise. Amount. Date. Classification. Conditional loan. Condition. Non-contestation of estate. Signature line. 2 signatures per letter, followed by Victor's signature as witness. I turned to the most recent letter. The date was 14 months before my grandfather died. The amount, $28,000. Both signatures, in the familiar handwriting I'd seen on birthday cards my whole life. Did they understand what they were signing? I asked. Victor was quiet for a moment. I can only speak to what the document says and what my role in preparing it was. I cannot tell you what they understood or chose to understand. He paused. What I can tell you is that the language was not ambiguous, and your grandfather reviewed every letter before it was sent. Total transfers across all 31 letters. $940,000. By initiating their lawsuit, Damon and Camilla Foster had triggered the condition they had signed their names to 31 times. The $940,000 they had received over 22 years was now, by the terms of their own signatures, a recoverable debt. They had come to take everything from me. They had forgotten that they had spent 2 decades signing their names to the reason they couldn't. I sat with that for a long moment. Then I picked up my pen and added Victor Ashby to the witness list. By the end of March, we had assembled what Margaret called the most comprehensive pre-hearing file she had seen in 30 years of estate litigation. The legal foundation, the trust agreement, properly executed and funded, removing all assets from probate jurisdiction. Holt had already discovered this. We could tell by the way his discovery request shifted in week 3, pivoting away from document challenges and toward exactly the narrative attack Margaret had predicted. He was no longer trying to invalidate the trust. He was trying to prove that the trust itself was the product of manipulation. The financial record, 22 years of documented transfers, Victor Ashby's letters, 31 signed acknowledgments, $940,000 in conditional loans, now technically due and payable. The medical record, Dr. Okafor's full file, covering 9 years of my grandfather's care, cognitive assessment scores, neurological evaluations, documented absence of any dementia markers or capacity concerns. A written statement, later formalized as testimony, that Stanley Wallace had been fully capable of independent legal and financial decision-making until the final weeks of his life. The visitation record. Margaret's investigative consultant had pulled together a comprehensive account of Damon and Camilla's physical presence in my grandfather's life over the preceding 5 years. Security footage from the Neighborhood Association's camera system. GPS, records obtained through the discovery process. Visitor logs from the hospice service. 7 visits in 5 years. Average duration, under 2 hours. Against that, my own record. Phone logs showing calls between my grandfather and me averaging 3 times a week over 5 years. My GPS records placing me at the Brookline address at least once a week for the same period. Testimony from Eleanor Gibbs, who had observed me at the house so regularly that she knew my car on site. The hospice nurse, Sandra Belknap, who stated in her written account that I had been present at the house 12 of the 14 days before my grandfather's death. And the journals. I found them on my 3rd visit to the house. 8 composition notebooks stored in the bookshelf behind his desk, each one dated on the spine. My grandfather had kept what he called bench notes since his early years as a judge, brief daily records of observations, reflections, whatever had struck him as worth preserving. He'd continued the habit in retirement. The entries weren't dramatic. They were quiet and specific in the way that quiet, specific things are more devastating than drama. Things like, Selena came Sunday. She brought the good bread from the bakery on Commonwealth. We played 2 games of chess and she won the second one. She started thinking 3 moves out. I didn't tell her I noticed. Camilla called this evening. She needed money. I sent it. I didn't tell her that the last time I saw her in person was 11 months ago. There didn't seem to be a point. Selena stayed late tonight to help me organize the study files. We talked about the Henderson case she's working on. She argued the prosecution's position and then, without being asked, argued the defense's. She's going to be better than I ever was. Dr. Okafor cleared me on all counts today. I'm sharper than men 20 years younger, she says. I told her that's a low bar. She laughed. 8 journals, 9 years, a running record of a man who was fully present in his own life, fully aware of the people in it, and fully clear about what he valued. Margaret read selected passages in her office, making small marks in the margins. These aren't just character evidence, she said. These are a real-time account of his mental state written in his own hand across 9 years. There is no credible argument of diminished capacity that survives this. I know, I said. She looked up at me. He thought of everything. He was a judge for 30 years, I said. He understood what a record is for. 6 weeks before the hearing date, Margaret formally requested a settlement conference. Under Massachusetts probate rules, the request was granted, and both parties were required to attend a preliminary meeting at Holt's offices to explore whether the matter could be resolved without trial. I knew they would use the meeting to pressure me. Holt would present it as an opportunity for a gracious compromise, a way for both sides to walk away with something rather than putting everything before a judge. What he was actually trying to do was get me to accept a partial surrender before he'd had to expose how thin his case was. The meeting was scheduled for a Wednesday afternoon in early April. Holt's offices were in a glass building in the financial district, the kind of space designed to communicate that the people inside it were powerful and that you would be better off agreeing with them than fighting them. We arrived at 2 o'clock. Holt and his associate were already seated at the conference table when we came in. Damon and Camilla were there as well. I hadn't seen either of them since the funeral. My father looked smaller than I remembered. He was wearing a good suit that didn't quite fit him the way it used to, like a man who had recently lost weight but hadn't had the clothes adjusted. He looked at the table when I walked in. My mother looked at me directly. She was composed, pink blazer, pearl earrings, the practiced presentation of a woman who had learned long ago that appearance was a form of argument. I met her eyes for a moment. She held mine, steady. I sat down. Margaret sat beside me. I placed my hands flat on the table. Holt opened with the tone he was clearly most comfortable with, warm, reasonable, a little sorrowful, the voice of a man who wished none of this were necessary. I think we all want the same thing here, he said. We want to honor Stanley Wallace's memory and ensure that his family is treated fairly. The question is whether we can find a way to do that outside of a formal hearing. He looked at me with an expression calibrated to suggest sympathy. Selena, I know this has been a painful time. Your mother has also lost her father. There may be a way to acknowledge both of those realities without... Before we go further, Margaret said pleasantly, I want to make sure you have complete information. And she looked at me. I reached into the briefcase beside my chair and placed a document binder on the table. Dark blue cover, 4 inches thick. I set it in the center of the table. Not toward Holt, not toward my parents, directly in the center, equidistant from everyone, and left my hand on it for a moment before pulling back. This contains 22 years of financial records documenting $940,000 in transfers from Stanley Wallace to Damon and Camilla Foster, Margaret said. Each transfer is accompanied by a signed acknowledgement letter drafted by Stanley Wallace's accountant, classifying the transfer as a conditional loan. The condition, non-contestation of Mr. Wallace's estate or estate planning decisions. By filing their petition, your clients have triggered that condition. The full amount is now legally recoverable. She paused. The binder also contains the certified trust agreement, fully executed and funded 3 years before Mr. Wallace's death, removing all disputed assets from probate jurisdiction. And it contains 9 years of Mr. Wallace's personal journals, medical records establishing full cognitive capacity, and a documented visitation history showing 7 visits over 5 years. The room was very quiet. Holt looked at the binder. He looked at Damon. He looked at Camilla. I looked at my mother. For the first time in my memory, past the eye rolls, past the composed arrivals and early departures, past the birthday cards that came a week late, I saw something in her face that I hadn't seen before, something that looked, underneath the pink blazer and the pearl earrings, like the beginnings of fear. My father continued to look at the table. Holt picked up the binder, set it down. We'll need time to review. Of course, Margaret said. Take all the time you need. The hearing date remains as scheduled. We stood up. I picked up my briefcase. I looked at my mother one more time. Not with anger, not with satisfaction, just looked, and then I followed Margaret out of the room. In the elevator going down, Margaret said nothing for a moment. Then, "You didn't flinch." "No point," I said. She nodded, as though this confirmed something she'd already suspected. 4 weeks before the hearing, under Massachusetts probate rules, both parties were required to attend mandatory mediation, a structured session with a neutral third-party mediator to make a genuine attempt at resolution before the matter went before a judge. The mediator was a retired family court judge named Arthur Pennington, 64, with a reputation for being harder on the party with the weaker case. That reputation did not appear to concern Holt. We met in Pennington's conference room on a gray Tuesday morning in late April. The room had large windows overlooking the harbor. Coffee had been set out on a credenza. No one touched it. Pennington opened with a brief statement about the mediation process: confidential, non-binding, an opportunity for both parties to be heard, and then turned to Holt. Holt presented his client's position for approximately 20 minutes. The story he told was familiar by now. Devoted daughter, grieving father, a granddaughter who had positioned herself as indispensable and gradually steered a vulnerable man away from his real family. He spoke about Camilla's love for her father, her pain at feeling shut out, her desire only for fairness. Then he said that he had something new to share. He placed a printed email on the table and passed copies around. The email was from my grandfather's address to Camilla's, dated the previous summer, about 8 months before he died. The portion Holt had printed read, "My daughter deserves more than what she has." Holt let that sit for a moment. "This email," he said, "demonstrates that Stanley Wallace himself had concerns about the distribution of his estate and felt that Camilla was not being treated equitably. We believe this undermines any claim that his estate planning decisions were made with full confidence and without outside pressure." Pennington looked at the email, then at Margaret. Margaret had not moved. She was reading the email with the calm attention of someone who already knew something the room didn't. "Mr. Pennington," she said, "I'd like to invoke Rule 106, the rule of completeness. This email appears to be an excerpt from a longer communication chain. I'd like to request the complete thread." Holt's associate, a young woman who had been taking notes at the end of the table, looked at Holt. Something passed between them. "The portion I've shared is the relevant, I understand your position," Margaret said, with the particular patience of a person who is not actually asking. "But the rule of completeness exists precisely so that selective quotation cannot be used to misrepresent a document's full meaning. I'm requesting the complete chain. If it isn't provided here, I'll file for it formally before the hearing." Pennington said, "Produce the full chain, Mr. Holt." There was a pause. Not long, but long enough. Then Holt's associate opened her laptop and printed something from her email. She walked it to the table and placed it face down in the center. Margaret picked it up and read it without expression. Then she read it aloud. "My grandfather's email to Camilla, complete in full. My daughter deserves more than what she has. My daughter has built a life through her own hard work and integrity and has been present in mine when I needed her most. My daughter is Selena, not you." The room did not make a sound. I kept my eyes on the table in front of me, on the grain of the wood, on my own hands lying flat on the surface. My throat had tightened in a way I hadn't allowed it to since the day I found the box. At the end of the table, Damon looked at the floor. Camilla looked at the wall of windows, at the gray harbor outside. Pennington set down his copy of the email and looked at Holt for a long moment. "I think," Pennington said slowly, "that we should take a brief recess." No agreement was reached at mediation. No settlement was offered or accepted. We left the building and walked out onto the waterfront, and the wind off the harbor was cold even for late April, and Margaret said nothing for a full block. Then she said, "The hearing is in 4 weeks. Are you ready?" I thought about my grandfather's handwriting on the lid of that box. "When it's time." "Yes," I said, "I'm ready." The morning of the hearing, Boston woke up gray and cold. It was a Monday in late May, but New England hadn't gotten the message about spring yet. The sky was the color of old concrete, low and flat, pressing down on the city like a hand. I stood at my apartment window at 6 in the morning with a cup of coffee and watched the street below. A delivery truck, a woman walking a dog, a man in a raincoat moving fast with his head down. And I thought about my grandfather. Not about the case, not about the documents, the witnesses, the strategy, just about him. About the way he used to sit in the kitchen on Sunday mornings in his reading glasses and his flannel shirt, before he'd gotten properly dressed for the day, working through the newspaper with a pencil, marking things he wanted to think about later. About the way he'd look up when I came in and say, without preamble, whatever was on his mind, some question about a case I was working on, or a thought he'd had about something I'd said the week before, as though our conversations were one long continuous thing that simply paused between Sundays and resumed. I had worn his favorite color when I dressed that morning, a dark navy blue. I had a suit in that color that I'd bought for a particularly important trial 2 years ago and saved for occasions that required it. I put it on carefully, checked myself in the mirror, and thought, he would have said, "You look like a lawyer," which, from him, was the highest possible compliment. I picked up my briefcase and left. Suffolk County Probate and Family Court sits on Tremont Street, a solid brick building that has housed the legal disposition of family matters, wills, guardianships, estate disputes, the quiet bureaucracy of death and inheritance, for longer than most of Boston's newer landmarks have existed. I had been inside it before, in a professional capacity, but never as a party to a case. Margaret was waiting on the steps when I arrived. She was in charcoal gray, her silver hair neat, her expression the same as it had been every time I'd seen her over the past 3 months, composed, attentive, ready. She looked at me and gave a small nod that said everything it needed to. "Derek's inside," she said. "Patricia Okafor is here. Eleanor Gibbs came early and has already told the security guard that she hopes justice gets done today." Despite everything, I almost smiled. That sounds exactly right. We went in. The courtroom was smaller than the federal courtrooms I was accustomed to. Wood paneling, tall windows, the smell of old paper and institutional cleaning solution. The gallery had perhaps 20 seats, half of them filled by the time we entered, a few people I didn't recognize, 2 reporters I recognized from local outlets, and in the back row, Professor Harold Simmons, who had come without being asked to, and who caught my eye and gave a single, dignified nod. Derek Ashford was seated in the gallery as well, in his good coat, looking like the solid, steady person he had always been. He raised his chin at me when I came in. I raised mine back. At the table to my left, Richard Holt and his associate already seated, papers arranged before them with the careful architecture of men who believe in the power of visual preparation. Beside them, Damon and Camilla. My father was looking at the table again. I was beginning to think it was the only place he felt safe looking. My mother was watching me walk in. She was in white again. Ivory, technically, a blazer with a soft collar, the color of someone who has made deliberate choices about how they want to be perceived. She watched me cross the room with an expression I couldn't quite read. Not triumphant, not frightened, something in between, held together with the effort of a woman who had been performing composure her entire adult life. I sat down, placed my hands flat on the table, looked straight ahead. The door at the front of the courtroom opened and the clerk called for order, and we rose, and the judge came in. His name, as listed on all the case documents, was the Honorable James Whitford. I knew that name. I had known it since I was 9 years old. When my grandfather talked about his years on the bench, not often, but sometimes, on quiet evenings when the conversation drifted toward the past, he occasionally mentioned the clerks he'd worked with. Young lawyers, fresh from law school, who spent a year or 2 in his chambers learning what it meant to be inside a court rather than in front of one. He had mentored perhaps a dozen over the years. Most he mentioned in passing. One he mentioned by name more than once. "I had a clerk once," he'd said to me, I think when I was around 12 or 13, "named James. Sharp as anyone I've ever worked with. The kind of mind that could read a case and immediately understand not just what it said, but what it was trying to avoid saying. He's going to be important someday." He'd said it with the particular quiet satisfaction of a teacher who has watched a student become more than the lesson. James Whitford, now 56, now sitting on the bench of the Suffolk County Probate and Family Court, adjusting his reading glasses and opening the case file with the unhurried attention of a man accustomed to taking the measure of things before speaking. I had recognized the name when it appeared on the case assignment 3 weeks before the hearing. I had not said anything to Margaret, not because I was hiding it, but because there was nothing to say. There was no conflict of interest to report. A professional relationship between a judge and a mentor 28 years in the past does not require recusal. Whitford had no personal stake in the outcome, no financial interest, no familial connection. What he had was something no other judge assigned to this case could have had: 28 years of memory. He had sat in my grandfather's chambers. He had watched how Stanley Wallace read a record, how he weighed evidence, how he thought about the difference between a person's stated intentions and their demonstrated ones. He had been trained by that man in the belief that documentation is the truest form of honesty, that what people do over time matters more than what they say in a single moment, and that a judge's job is not to be moved by the performance in the room, but by the record before them. Holt did not know any of this. Damon and Camilla didn't know. No one in the room knew except me, and I had not chosen it. It was simply there, the way certain things are simply there when you've lived inside a story long enough. My grandfather had not arranged it. He couldn't have known. But he had spent 30 years building the kind of legacy that outlasted him in people as well as in documents, and James Whitford was part of that legacy, sitting on the bench in his black robe, reading the file with the careful attention of a student who never forgot what he'd been taught. I looked at the bench, and for a fraction of a second, I felt something I hadn't let myself feel in months. Not confidence, not strategy, not resolve, but something older and simpler than any of those things. I felt like he was still here. Holt rose first. He was good. I want to be honest about that, because dismissing competent opposition is its own kind of blindness. He was well prepared, he was controlled, and he told the story he'd been building for months with the practiced ease of a man who had told similar stories many times. He spoke about Camilla's love for her father. He acknowledged the geographical distance, acknowledged that she hadn't been able to visit as often as she would have liked, and framed this not as indifference, but as the complicated reality of adult life, of careers and distance, and the particular difficulty of watching a parent age when you feel helpless to stop it. Then he pivoted to me. He described, carefully and without raising his voice, a pattern he called strategic proximity. The granddaughter who had made herself indispensable. The weekly visits, the phone calls, the presence that had gradually, he implied, never quite stated, crowded out the space where a daughter's relationship with her father might have breathed. He spoke about my professional background with what sounded like respect but functioned as suspicion. A federal prosecutor trained in persuasion, trained in understanding how people think and what they can be made to believe. He concluded by asking the court to look past the legal documents, which he acknowledged presented challenges for his client's case, and consider the human reality. The question, he said, is not just whether the paperwork is in order. It is whether the decisions that paperwork reflects were truly free. Judge Whitford listened without expression. When Holt sat down, he made a brief note and looked at Margaret. Margaret stood and said almost nothing by way of opening. 4 sentences. Your Honor, the evidence will show that Stanley Wallace was a man of full legal and cognitive capacity who made deliberate, documented, and legally sound decisions about his estate over a period of years. It will show that those decisions reflected a lifetime of values, not a moment of vulnerability. It will show that the people best positioned to assess his intentions are not the people who visited 7 times in 5 years, but the record he left behind. We'll let that record speak. She sat down. Judge Whitford made another note. He had the expression of a man who has learned to trust documents over performances and who recognizes after long experience the difference between an argument and a record. Holt called Camilla to the stand first. She walked to the witness chair with the careful composure of a woman who had prepared for this. She sat, smoothed her blazer, and folded her hands in her lap. Her voice, when she began to speak, was appropriately soft, not weak, but gentle, the tone of someone who wants to be understood rather than believed. She talked about her father. She talked about her childhood in the Brookline house, the values he had instilled, the pride she had always felt in who he was. She described her pain at watching the relationship between them grow more distant in his final years, at feeling shut out, at arriving at a point where she felt she had somehow lost access to her own father. I love him, she said, speaking in present tense, which was either an accident or a choice. I have always loved him. Holt thanked her warmly and sat down. Margaret rose and walked to a position directly in front of the witness stand. She had nothing in her hands, no file, no notepad, no paper of any kind. Just her attention, which she directed at Camilla with the focused, unhurried quality of a person who is not in any rush to get where she's going because she knows exactly where that is. Mrs. Foster, she said, I want to ask you some questions about your relationship with your father. Not about legal documents, not about estate planning, just about him as a person. Is that all right? Camilla nodded. What was the name of Selena's 6th grade homeroom teacher? A pause. I'm not sure I would know that. What was the name of the dog Selena had when she was 9? Another pause, slightly longer. Selena wasn't living with us when she was living with your father, Margaret said, simply. I'm asking whether you know. Do you? Camilla's jaw tightened slightly. No. What is Selena allergic to? Silence. Margaret waited. I'm not certain. Margaret turned to the binder on her table, opened it to a tabbed page, and read without theatrical emphasis, just clearly. Patient presented at age 8 with allergic reaction following antibiotic prescription. Penicillin allergy confirmed. Guardian notified and provided updated emergency contact information. Guardian, Stanley Wallace. That's from the pediatric record, dated when Selena was 8 years old. She closed the binder. Your father knew. He was the one who brought her in. He was the one who updated the emergency contacts. She paused. You didn't know. Camilla said nothing. In the 5 years before your father's death, Margaret continued, according to records obtained through discovery, you visited the Brookline home 7 times. Is that consistent with your recollection? A long pause. I had a demanding schedule. We spoke on the phone. 7 visits in 5 years, including the visit 14 months before he died, which lasted approximately 90 minutes. Margaret looked at her without hostility, which was somehow worse than hostility. Mrs. Foster, I'm not asking these questions to be unkind. I'm asking them because your attorney has argued that Selena's closeness to your father was somehow suspicious, that being present in someone's life is evidence of manipulation rather than evidence of love. She let that land for a moment. I want the court to understand what presence actually looked like in your father's life, and what absence looked like. Holt objected, argumentative. Judge Whitford considered for a moment. I'll allow it. The witness may answer. Camilla looked at her hands. When she spoke, her voice had lost the careful softness of her prepared testimony. I know I wasn't there enough, she said. I know that. No further questions, Margaret said quietly and sat down. Damon's testimony was brief. Margaret kept her cross-examination to 3 questions. Did he attend Selena's law school graduation? He had not. Had he ever, in the time Selena lived with Stanley Wallace, contacted her teachers, her doctors, or any of the institutions responsible for her welfare? He had not. When was the last time he had spoken to Stanley Wallace on the phone before his death, not to ask for money, but simply to speak with him? He thought about this for a long time. Maybe 2 years before he died, he said finally. Maybe a little more. Margaret nodded and sat down without another word. After the witness testimony, after the documentary evidence had been formally entered into the record, the trust agreement, the financial records, the acknowledgement letters, the medical files, the journals, Margaret rose and addressed the judge. Your Honor, I have one final item to enter into evidence. It is a letter written by Stanley Wallace in his own hand and left with his personal documents alongside the trust. It is addressed not to any specific person, but, in his words, to anyone who questions. She looked at the judge. I'd like to read it into the record, with the court's permission. Judge Whitford looked at the document already submitted. Proceed. Margaret held the letter, 1 page, standard paper, the clean, even handwriting I knew from 22 years of birthday inscriptions and chess game annotations and the note on the lid of the wooden box. She read without performance, just the words, in his voice, which was enough. To anyone who questions, I am writing this in the spring, 3 years before I expect to die, though one is never entirely certain about such timelines. I am writing it because I have spent 30 years as a judge and I understand what happens when intent is not documented. I am writing it because I know my daughter and I know what she is capable of, and I would rather speak plainly now than be misrepresented later. I built what I have over 40 years. I built it the way my father built furniture, carefully, without waste, with attention to whether the joints would hold. I did not inherit it. I did not receive it. I earned it, in the specific sense that I traded years of careful living for it, and I am entitled to decide where it goes. My daughter Camilla is my blood and I love her. I have sent her money for 22 years because she needed it and because I did not know how else to reach her, and because a father does not stop hoping even when hope is not rational. I do not regret the money. I regret that the money was the only language we had left. Selena Foster came to me as an infant and became, without any legal ceremony or formal declaration, the most present person in my life for 34 years. She was there when Irene died. She was there every Sunday. She was there when I needed someone to argue with about case law, and when I needed someone to sit quietly in the same room, and when I needed someone to drive me to a doctor's appointment and pretend it wasn't difficult for either of us. She never asked what she would receive. She never positioned herself. She simply showed up consistently for decades because that is who she is. I am not leaving my estate to Selena because I was confused. I am not leaving it to her because she manipulated me. I am leaving it to her because she is, by every measure that matters to me, my family. Not by blood, by record, by the accumulated evidence of 34 years of presence. If anyone disputes this, I have left the documentation. I spent 30 years on the bench believing that records tell the truth that people are sometimes afraid to say aloud. I believe it still. I am trusting the record to speak for me. I am not leaving my estate to the person who carries my name. I am leaving it to the person who showed up. I believe those two things should have been the same. They were not. That is not Selena's fault. Stanley R. Wallace. Margaret placed the letter carefully on the exhibit table and sat down. The courtroom was completely still. I was looking at the wood grain of the table in front of me. My hands were flat on the surface. Somewhere behind my sternum, something was pulling tight, and I breathed through it, slowly, the way you learn to breathe through things when you've had a lot of practice. Judge Whitford sat with the letter before him for a long moment. He read it again, silently, all the way through. Then he set it down, removed his reading glasses, and looked at the room. His gaze moved from the letter to my grandfather's journals, stacked on the exhibit table, to the binder of financial records, to the trust agreement with its notarized seal. He looked at these things the way a person looks at something they recognize, not the documents themselves perhaps, but the mind behind them, the method, the belief that truth, properly recorded, can survive the person who holds it. I wondered what he was remembering, whether there was a specific moment, a conversation in chambers, a lesson over a case file, a comment about evidence and record keeping, that he was seeing in a different light now. He put his glasses back on. After reviewing the complete record submitted by both parties, he said, the court finds as follows. His voice was measured, deliberate, the voice of a man who chooses words with care. First, with respect to the trust agreement, the revocable living trust established by Stanley R. Wallace was properly executed, properly funded, and legally valid at the time of his death. The assets held within the trust passed to the named beneficiary outside of probate jurisdiction. The petition challenge through probate proceedings has no legal basis with respect to these assets. On this ground alone, the petition fails. Holt was making notes on his legal pad without looking up. Second, with respect to the claim of undue influence, the court finds no credible evidence, none, that Selena Foster exerted improper influence over Stanley Wallace's estate planning decisions. To the contrary, the evidence establishes that Mr. Wallace was cognitively intact, that his decisions were deliberate and documented over a period of years, and that his estate planning choices reflect consistent values demonstrated across decades of his life. The claim of undue influence is without merit. He paused. The petition is dismissed. Attorney's fees and court costs are awarded to the respondent. The gavel came down. The sound of it was smaller than I expected. A single clean sound in a quiet room, and then the rustle of people beginning to move, Holt's associate gathering papers, the clerk making notes, voices starting up in the gallery behind me. Margaret put her hand briefly on my arm, not a celebration, just acknowledgement. This happened. It's done. I exhaled slowly, and for a moment I just sat there with my hands on the table and let the room come back to me piece by piece. The gallery emptied quickly. Holt was speaking in low tones to his associate. Damon had stood and was putting on his coat with the careful movements of a man who doesn't know what to do with his hands. I was gathering my files when I heard footsteps approaching. I didn't need to look up. Selena. My mother's voice, lower than usual. The careful softness of the witness stand was gone. What was left was something smaller and I think more real. I finished securing the clasp on my briefcase before I turned around. She was standing 2 feet away, without the courtroom between us, without the ivory blazer doing its work, without anything to perform for. She looked, for the first time I could remember, like a woman who was tired of performing. I know that nothing I say right now is enough, she said. I looked at her. I had spent 34 years trying to locate in the specific angle of her face or the specific tone of her voice something that looked like she was actually seeing me. I thought about the birthday cards, the graduated early from the reception, the phone calls to my grandfather that began with how hard things had been and ended with an amount. No, I said, it isn't. I want you to know Camilla. I used her name because it was the honest name for what she was, not because I wanted to hurt her, but because I had stopped being able to pretend. I don't have anything to say to you right now. Maybe not ever. I haven't decided. I picked up my briefcase. What I know is that whatever happened in this room today and whatever happens after, I'm going to be okay. I've always been okay. That's the thing you and Damon never understood. He made sure of it. She didn't say anything else. I don't know if that was because she had nothing left to say or because she finally understood that I meant it. I walked past her and out of the courtroom, into the marble corridor, and then through the glass doors and down the front steps into the gray May morning. The call started within the hour. Derek, I'm buying dinner. You don't get a vote. Dr. Okafor, I am very glad the record was sufficient. Eleanor Gibbs, I told that security guard this morning. Justice, I told him. Professor Simmons left a voicemail that was 3 sentences long, each one chosen with the same care he brought to everything, and I listened to it twice on the drive back to Brookline. I drove to the house. I sat in my grandfather's study for a long time that evening, not doing anything specific, not reading, not working, not planning, just sitting in his chair, in the room that smelled like him, with the wooden box on the desk in front of me. The room was getting dark, and I didn't turn on the lights. The street lamp outside came on at some point and threw a pale rectangle across the floor. I thought about the first time I had sat in this chair, the day after receiving the petition, the day I opened the box and understood what he had done. I had thought then that the box was his gift to me, his preparation, his documentation, his careful construction of a defense he wouldn't be alive to give himself. I understood now that the box was only the last gift. The real gift had been everything before it. The 34 years, the Sunday dinners, the chess lessons, the library trips, the front row seat at every small ceremony of my life. The box was the armor. The years were the person it was built to protect. In the weeks that followed, I made the decisions about the estate with Margaret's guidance, the Brookline house I kept. This surprised some people, including Derek, who had assumed I might sell it and buy something closer to the office. I couldn't explain it easily except to say that the house was not an asset to me. It was an address that meant something. Ba Irene's tulip bulbs were still in the garden, tended, I discovered, by Eleanor Gibbs, who had quietly watered and divided them every spring for 3 years, while my grandfather's health declined and then after he was gone. When I knocked on her door to thank her, she waved her hand dismissively and said, "Someone had to." The investment accounts and rental property I managed through a financial advisor recommended by Victor Ashby. I lived on my salary, the way my grandfather had always insisted a person should, from what you earn, not from what you've inherited. From the estate, I set aside a specific sum to establish a scholarship fund at my grandfather's law school, not in my name and not in a way that required ceremony or announcement. I asked that it be named the Wallace Fund, that it go to students demonstrating financial need and academic merit, and that no publicity be attached to it. The law school's development office sent a letter of confirmation. I filed it in the wooden box beside the last of his journals. As for the $940,000 in conditional loans, the 31 signed letters that Damon and Camilla had triggered when they filed their petition, Margaret presented me with a clear-eyed summary of my legal options. The debt was enforceable. Victor Ashby's documentation was airtight. If I chose to pursue it, the outcome was not in serious doubt. I thought about it for 3 days. Then I called Margaret. "I'm not going to pursue it," I said. A brief pause. "That's your decision to make." "My grandfather didn't document those loans to collect them," I said. "He documented them to protect me from exactly what happened. The protection worked. That's what the record was for." Another pause, shorter this time. "All right." "He wasn't a vengeful man," I said. "I don't want to become something he wouldn't recognize." The first truly warm weekend came in early June. I drove to Brookline on a Saturday morning and spent the day in the garden. Not because I particularly know what I'm doing in a garden, but because it felt like the right place to be. Eleanor came over at noon with sandwiches, and we ate on the back step, and she told me things about my grandfather I hadn't known, that he used to leave books on her doorstep when he thought she'd like them, that he had once spent an entire afternoon helping her dispute an incorrect property tax assessment because he thought it was wrong and he had the knowledge to help, that in the final months, when he was too tired to spend long in the garden himself, he used to sit in the chair by the back window and watch her work and hers through the fence. He liked watching things that were alive and growing, she said. I think it made him feel like things were continuing. In early June, the tulips that Ba Irene had planted decades ago came up again, the way they always did, red and yellow and orange, in the bed by the back fence. I had been coming to this garden my whole life. I had watched those flowers come up every spring and taken them for granted the way you take for granted the things that are simply always there. I stood at the edge of the bed and looked at them for a long time. He used to say, "A record doesn't lie. A record is just what happened, written down. It doesn't feel anything, it doesn't want anything, it just is." And that's why it lasts. Because the truth doesn't need to want anything, it just needs to be documented carefully by someone patient enough to believe it will matter eventually. He was the most patient man I ever knew. Damon and Camilla did not contact me after the hearing. I did not contact them. I don't know what they thought or felt in the weeks that followed, and I have made a conscious and ongoing decision not to spend energy imagining it. They are people I share biology with. They made their choices over 34 years, and those choices produced eventually a courtroom. I carry no hatred for them, but I have also stopped carrying hope on their behalf, and the absence of that particular weight has made me lighter than I expected. In October, I went to Mount Auburn Cemetery for the first time since my grandfather's funeral. The day was cool and bright, the kind of autumn afternoon that looks like a painting of autumn more than like actual autumn. I brought flowers, not tulips, it was the wrong season, but small white dahlias that I'd found at a stand near the cemetery entrance. I stood between the two headstones for a while. Stanley Raymond Wallace, Irene Catherine Wallace. The dates, the names, the stone that was already beginning to weather at the edges the way stone does. I didn't say anything for a long time. Then I said, "I kept the house." The wind moved through the leaves overhead. Somewhere across the cemetery, a bird called once and went quiet. "Eleanor says the tulips came up really well this year," I said. "She's planning to add more bulbs in the fall." I stood there until the light started to go gold, and then I put the dahlias down at the base of the stones and walked back to my car. There's a question I get asked when I tell parts of this story to people who knew my grandfather or who knew me, whether I'm angry, whether I resent the years of absence, the lawsuit, the attempt to take what he built and use it against me. The honest answer is that I was angry. Briefly, the night I sat on the floor of his study and read 22 years of records by the light of his desk lamp. The anger was real, and I didn't try to perform my way past it. But anger without direction is just weather, and I have a prosecutor's training in not letting weather make decisions. What replaced the anger over time was something more durable and more useful. He used to say, "The record is what survives. Everything else is argument." He was right about most things. He was right about that. He left me a house, an estate, a trust, a box of documents. But what he really left me, the thing no one could have petitioned a court to take, the thing Holt could never have found in a filing or challenged in a deposition, was the 34 years that preceded all of it. The presence, the consistency, the evidence of a life lived in a particular direction. He left me, in other words, exactly what he said he was leaving me. Not his name, his record. And his record was everything. Family isn't proved by blood. It's proved by presence. And presence, if you pay attention, leaves a record. He had 34 years of it. I only needed to open the box. Thank you for staying with me through this entire story. If this reached you, whether you're in Boston or somewhere I've never been, whether it's morning where you are or the middle of the night, I'm genuinely grateful you spent this time here. If any part of this story stayed with you, if it reminded you of someone you love or someone you've lost or something you've had to fight for, I'd love to hear about it in the comments. Stories don't really end when the telling stops. They keep going in the people who carry them. And if you haven't subscribed yet, please do. There are more stories coming. Stories about ordinary people who faced extraordinary moments and found, usually when they least expected it, that they were more prepared than they knew. I'll see you in the next one.